Good afternoon. My name is Kim Sanger. I'm the head of Holland and Hart's Healthcare Group, and we are very pleased to welcome you to, I think, our last webinar of this year, unless something crazy happens before now at the end of the year. Today, we're going to be talking about the healthcare compliance, kind of a review of everything that's gone on in the past year and an alert concerning everything that's going to be happening at the first of next year.
Emma, your mic cut out. Not able to hear.
Thank you very much. I'm so sorry about that. Just to get you up to speed then, we're just going to be covering, doing a quick run of the top issues for 2021. The first one we wanted to cover, of course, is the vaccine mandates, which has been quite a roller coaster over the past few weeks. First is the CMS vaccine mandate. As you know, it was on again, off again. Right now it's off again because of the injunctions, the preliminary injunctions that have been granted around the nations. There is the initial one came out of the District of Missouri. It was a preliminary injunction in response to a lawsuit that was filed by 10 states. That was appealed to the 8th Circuit. At CMS moved to stay the injunction at the 8th Circuit, so basically to reinstate the mandate while there's a litigation is going on. But the district court refused to do that. The 8th Circuit has asked for a briefing. The plaintiffs, I understand, were supposed to file their brief on that yesterday, so we'll have to see how that plays out. Now, the Missouri mandate or injunction only applied to those 10 states. In Louisiana, there was several other states that filed another lawsuit. There was a separate injunction entered in that lawsuit that applied to all the rest of the nation. That has also been appealed by CMS to the 5th Circuit. CMS, as in Missouri, has moved to stay that injunction, but so far the 5th Circuit has not acted on that. Separate apart from those, there was a separate lawsuit filed in Florida. Unlike the other two, the district in Florida refused to grant the injunction. That has been appealed to the 11th Circuit. The 11th Circuit denied the state's request to stay the district court's decision. The bottom line here is we've got some conflicting decisions. We've got it at the circuit court level. There's possibility of disputes in the circuit. The bottom line is it's probably heading towards the Supreme Court on some kind of a fast track. In the meantime, however, CMS issued its issued a guidance stating that it's not going to enforce the new rule regarding the vaccination of healthcare workers or requirements for policies and procedures in certified Medicare and Medicaid providers while there are court-ordered injunctions in place prohibiting enforcement of this provision. So if you are a CMS covered entity, you don't have to worry about the CMS vaccine mandate, at least for the time being. Interestingly, in the guidance that CMS sent out, or that informational letter, they did state that healthcare facilities, of course, may voluntarily choose to comply with the interim final rule, but since the interim final rule has stayed, there's nothing that requires you to do that, and at least most of my clients probably don't want to go there, at least right now. Now, that is only one of the vaccine mandates. There's also, as you may know, the OSHA large employer mandate. This generally requires employers with 100 plus employees to require full vaccination or weekly testing by January 4th. They've at least got a testing option there. That, of course, was enjoined by the 5th Circuit. They imposed a nationwide injunction because of the rules that are applicable to those types of cases. That was consolidated cases were transferred to the Sixth Circuit. So the Sixth Circuit now has that. This Sixth Circuit recently denied OSHA's motion to dissolve the stay, so that injunction is still in place. We'll have to see how that plays out in the courts. In the meantime, yesterday, the Senate voted to repeal the employer mandate. We don't know exactly where this is going to go. Again, I don't think that it's going to be a legislative issue. I doubt that the House will support the Senate's resolution. Even if they did, I doubt that President Biden would accept that. He'd probably veto it. I think more likely it's going to have to play out in the courts. If it stands, there has been some confusion concerning the scope of the large employer mandate, particularly when it applies to healthcare entities. The large employer mandate, which again applies to employers with more than 100 employees, has an exception that it does not apply in healthcare settings that are subject to the OSHA healthcare ETS. So if you are a healthcare provider or a setting that is subject to the healthcare worker ETS, then you are not subject to the large employer mandate. So let's talk briefly about that. As you may know, I don't pretend to be an OSHA lawyer, but you should, I'm assuming you're all aware of the OSHA ETS that's out there for healthcare workers that was issued earlier this year. It generally applies in all settings where any employee provides healthcare services or healthcare support services, such as laundry or the like. It imposes pretty onerous requirements to protect against COVID-19, including having plans, PPE, physical barriers, physical distancing, all of those types of things. Now, the OSHA ETS for healthcare workers does contain an exception. It does not apply to certain settings, certain limited settings, including well-defined hospital ambulatory care settings where all employees are fully vaccinated and all non-employees are screened prior to entry, and when people with suspected or confirmed COVID-19 cases are not permitted to enter. So in those settings, the OSHA OTS does not apply. That means that it's not subject to the exception for the healthcare ETS. Therefore, these entities that fit within this exception for the healthcare ETS, those healthcare entities may be subject to the OSHA large employer vaccine mandate, at least for those healthcare settings. For more information about that OSHA ETS, it's received a lot of criticism, but there you go. So far, it's still in effect. You can access that information at the OSHA website. There's also the federal contractor vaccine mandate out there. It, as of a couple of days ago, has also been stayed. The District Court of Georgia issued a preliminary injunction. If it hasn't already been, it's likely to be appealed to the 11th Circuit, so we'll have to see how that goes out. I've gotten a lot of calls from people who wonder if, hey, if I'm simply a Medicare provider, does that mean that I'm covered by this? And no, I don't think that that's what it was intended to do. It's intended to apply to those entities that contract with the federal government to provide services on behalf of the federal government. I have never seen anything that suggests that it's intended to extend simply to participation in Medicare or Medicaid. If it did, you really wouldn't need the CMS rule. So that is kind of the quick status of the vaccine mandate. Some additional considerations. Remember that those pending injunctions only apply to the federal mandates. They do not apply to state mandates, and there are some states that have imposed their own state mandates, like Colorado or others. It also does not apply to voluntary mandates. So if you're at a hospital or another facility that decides to impose their mandate, they're not affected by the federal mandates that apply to the those federal mandates. So far, there have been court challenges to those state and voluntary mandates, but generally those have all been upheld in the courts, so long as they allow for medical or religious exemptions. Now, in addition to those states that require mandates, there are some states that have enacted laws that affect vaccine mandates. For example, some states like Montana have actually prohibited vaccine mandates. Others, like Utah or perhaps others, require additional exemptions for vaccine mandates. So it would allow personnel to refuse to get vaccinated if they have, should not say personally held religious beliefs, but personally held convictions. So it doesn't necessarily have to be religious based. So the bottom line there is, as you're going forward or when you're in this limbo period, when we don't know the status of the rules, make sure that you know and comply with your local laws while waiting for the federal decisions. Otherwise, I think that you can suspend the action on the federal rules. You don't need to take action right now. You can put a pause on that and wait and see how those courts play out, unless you want to impose your own mandate. All right, that is an update on the vaccine mandates. Let's talk about the no surprise billing rules that take effect January 1st, 2022. It's helpful to understand the context of these. The Congress was concerned about situations when an uninsured or self-pay patient receives an unexpected medical bill. They can be hit with a huge bill that they have no idea that they were going to get or how they're going to pay. It can apply especially if an insured patient receives unexpected medical bill from an out-of-network facility or provider, including a situation where an emergency services are rendered by an out-of-network facility or provider, or the out-of-network providers at an in-network facility bill separately from the facility. You go to an in-network facility, you thought that you were all covered, only to get a bill from a radiologist or an anesthesiologist or a surgeon that you did not know was out of network, and suddenly you have this large out-of-network expense. Well, that's what the surprise billing rules were designed to protect against. They're part of the No Surprises Act that Congress passed. HHS came out with a bunch of other entities came out with the no surprise billing rules. There's two parts to the rules. The first part deals primarily with insured patients and out-of-network providers. The second part deals with the self-pay patients. Part one of the rule, dealing with insured patients, situations where the patient's insured but has dealing with an out-of-network provider, issued back in July. That's the part one rule. It essentially limits the amount that an out-of-network provider or facility may bill a patient and payer for certain emergency services that are provided at emergency facility, or non-emergency services that are provided by an out-of-network provider at an in-network facility, or certain air ambulance services that are provided by an out-of-network provider. In addition to placing the limits on the amount that provider can charge, those entities also have to provide a notice of patient rights to the patient. If there's a dispute concerning the amount of the out-of-network payment that the provider should receive, then the rule set up an independent dispute resolution process. In part two of the rule that issued in July, we actually got the details concerning that IDR process. Now, that's an overview of the insured patient rules. The protections for self-pay patients state that providers and facilities now must give a patient a good faith estimate of the charges if that patient is self-pay. So they've got to find out whether or not the patient's self-pay. If they do, then the patient has a right to get this good faith estimate of charges. If the amount comes back greater or substantially in excess of that good faith estimate, then the patient can initiate a selected dispute resolution process, which will determine how much the patient has to pay. Again, there are notice requirements to the patient of their rights. If you violate these under the No Surprises Act, you can get hit up with a civil penalty of $10,000 per violation. In addition, you can be limited or denied payment. We'll have to see how that penalty structure actually works. We need more clarification from the government on that, but in the meantime, the act itself says that you're potentially exposed to a $10,000 civil penalty. Let's talk first about the rules for insured patients. These are situations where you've got an insured patient and we're dealing with an out-of-network provider. Now, the first thing to remember is the limited scope of this. This does not apply to all out-of-network situations. It only applies to out-of-network providers or out-of-network facilities when there are emergency services are provided by an out-of-network provider or out-of-network emergency facility. So the first situation applies to emergency services that are provided by an out-of-network provider or an out-of-network emergency facility. For purposes of that rule, a facility is an emergency department of a hospital or an independent freestanding emergency department that's licensed by the state. That's the first situation. The second situation is these rules can also apply if you have a non-emergency services that are provided by an out-of-network provider at an in-network healthcare facility. For purposes of this rule, the facility means a hospital outpatient department, critical access hospital, or ASC that has a contract with a health plan covering the services provided. It does not apply to just most physician practices unless you're affiliated with a facility or providing emergency services in a facility. It also applies to air ambulance services that are furnished by an out-of-network provider of air ambulance services. So it doesn't apply in all healthcare settings. These out-of-network payment rules only apply in those limited circumstances. The first part of the rule places the limit on your ability, that out-of-network provider's ability, to balance bill the patient. It basically states that the patient's cost-sharing amount for the out-of-network services can be no higher than the in-network level. That is, if the patient's cost-sharing amount for an in-network service would be 20%, then the patient's cost-sharing amount for that out-of-network service is also 20%. That's the percentage. But what about the total amount that can be charged to the patient? The amount to which that cost-sharing percentage applies is called the recognized amount. That amount is determined by the following in decreasing order of priority. First, you would look at the amount determined by an applicable all-payer model agreement, if you have one in place for your jurisdiction. If not, if there's, you'd look at any amount that's determined by state law. If there is no state law, then you would look at the bill charge, either the bill charge or the qualifying payment amount, the QPA. The QPA is really important in the whole no surprise billing rule. The QPA is generally the plan's median contracted rate in 2019 for the same or similar items or services provided by a similar provider in the same geographic region, adjusted by CPI. So that's the standard for the amount that you can charge a patient if you're going to try to balance bill them. Now, there are ways that you can get out of those balanced billing limits. An out-of-network provider or facility may avoid those limits if, prior to rendering those services, you give the patient a required written notice of their patient's rights concerning those limits on balanced billing, and you obtain the patient's written informed consent to bill above the limits on cost sharing. And there's a form that you give to them. Now, in addition to that, you would have to notify the insurers that you are balance billing above the appropriate or the otherwise permissible limits. Now, even though this gives you the option or the ability to at least ask the patient for informed consent, I really question how often this is going to be done. How many of your patients are going to come in, and especially after you give them all of this notice and you provide them with their written documentation, how many of them are going to say, yeah, fine, I'll be happy to pay you more than the amount that I'm required to pay under the balance billing rule? I doubt that it's going to occur that much, especially in an emergency situation. I suppose it might occur in situations where you've got a patient who really wants to get care by a particular provider, and the provider for non-emergency services, and the provider doesn't want to, refuses to give the care unless they agree to it, but it's probably not going to happen very much. In addition, even in those situations where the law would allow you to get consent to go above the balance billing rules, there are certain situations where the regulations state that under no circumstances can you even get that consent to go above, including if the services were provided as a result of unforeseen urgent medical needs. So basically the patient never had a chance to consent in advance, for pre-stabilization emergency services, or for certain other types of services simply aren't available for that consent, including anesthesiology, pathology, and so forth. The government has issued forms that you need in order to implement that. You can access those on that website, including the notice of patient rights that have to be provided to your patients, talking about the limits on your ability to balance bill. Also, the forms that you need in order to get the patient to sign and give you appropriate consent. Among other things, you've got to give them a good faith estimate of the charges and certain additional information that is pretty draconian. If you're going to go for that, good luck. I'm not sure how practical it is for most of you. In addition to those limits on balance billing, the balance billing rules applicable to insured patients also place limits on the amount the out-of-network provider can get paid from the payers. Essentially, it sets the cap as follows. The total amount paid to the out-of-network provider or facility, including any patient cost sharing amount, is equal again in this hierarchy. First, you would look to see whether there's an all-payer model. If there's no all-payer model, then you would look to the amount determined by state law. If neither of those apply, which is going to be most of your cases, then you would look to an amount agreed upon by the payer and the provider or facility during a 30-day open negotiation period. If the parties aren't able to come to some kind of agreement during that 30-day open negotiation period, then either party can initiate the independent dispute resolution process. So let's talk about that process briefly. In order to initiate the process within 30 days of receipt of a partial payment or denial, either party, presumably the provider, would send a notice to the other party stating that they're opening the open negotiating period. So within 30 days of getting that bill, or the payment or denial, you have to initiate this IDR process by sending notice to presumably the payer. That triggers the 30-day open negotiation period. So during that 30-day open negotiation period, the parties have to make a good faith effort to try to resolve the issue. If they cannot agree during the 30-day open negotiation period, then at the end of that 30-day period, either party may request IDR by filing a notice within 4 business days after the end of that negotiation period. Again, the notice is provided by HHS. You can go onto the government's website, and I'll give to you in just a moment, and you can access that required notice. Once you initiate that, you go through a process of selecting the IDR entity who's going to determine the matter. Once that IDR entity is selected, they, within 10 days, they will give you notice. The IDR entity will give you notice, and within 10 days, each party then submits their out-of-network rate offer. That has to be submitted both in a dollar amount and as a percentage of the QPA. As part of the information the insurer has to, or the payer has to provide to the provider, they have to give the QPA. They also can provide any additional information that's requested by the IDR entity and any additional information that, for example, the provider deems as appropriate that would affect the IDR's determination of what is an appropriate rate, such as the size of the practice or facility, meaning the number of employees, the practice specialty, the QPA for the applicable year for the same or similar item or service, or additional information that the party believes is appropriate. There is certain information that is not deemed to be appropriate, including what your usual and customary charges are. That simply does not appear to be relevant. At the time they submit that information back to the IDR entity, both parties also submit the IDR entity's fee. The winner receives a refund, the loser has to go ahead and pay. Within 30 days after that IDR entity is selected, the IDR entity then issues its written decision selecting one of the offers. Now, this isn't a situation where the IDR entity can come in there and split the baby or come up with a different amount. This is baseball arbitration, so they accept one of the 2 offers that are submitted. So you want to make sure that your offer is reasonable to increase the chance that you're going to get it picked. Now, the government has given standards on what they use to make that determination. The standard is that generally they have to, they select the offer, or they choose the offer based on the QPA for the applicable year for the same or similar item or service. They can consider the information requested by the IDR entity and the additional information submitted by the party. But they can only rely on information that is deemed to be credible. Now, when evaluating those factors, that information you submit, the IDR entity is generally required to accept the QPA amount, or the amount that's closest to the QPA, unless they can come up with really good evidence to justify why they would not choose the QPA. The guidance specifically says that the IDR entity must select the offer closest to the QPA unless the credible information submitted by the parties clearly demonstrates that the QPA is materially different from the appropriate out-of-network rate. Any additional information that they are relying on must clearly demonstrate that the QPA is materially different from the appropriate out-of-network rate. And if the IDR entity does not choose the offer closest to the QPA, the IDR entity's written decision must explain how the credible information demonstrates that the appropriate out-of-network rate is materially different than the QPA. The bottom line there is chances are it's the QPA is going to come out at the end. What's the effect of the decision? Well, it's binding on the parties. Generally, you can't appeal it. You can't go to court and get it within 30 days of the decision. The loser has to pay any of the balance that hasn't been paid yet back to the other party. The loser remains responsible for the IDR entity fee, and the winner's prepaid fee is refunded. So that's how the IDR process works. Unless you've got a really good justification, you're pretty much going to have to, if you're an out-of-network provider, you're going to have to look at the QPA and be prepared to accept the QPA. And that's a bit of a tough standard. Now, there's been a lot of criticism with the rule. This is still, the rule is still subject to review. It's possible that may be changed. We'll have to see how that plays out. All right, those are the rules for self-pay patients. Let's talk about those are the rules for insured patients. Let's talk about the self-pay patients. For self-pay patients, under the no surprise billing rule, if a patient shows up, wants to get care, if you are a convenient provider or facility, meaning you're the one where the patient's seeking care initially, then you've got to determine if the individual is self-pay by asking them if they're covered by a plan or insurance. If they have coverage, you have to ask whether the patient wants to have that claim submitted. If they're not, they're deemed to be a self-pay patient. If the patient's a self-pay patient, then you've got to inform the patient that they may obtain a good faith estimate of the expected charges upon either scheduling an item of service or upon their request. That you inform the patient by providing an appropriate written notice to the patient. You've got to post that prominently at your facility, in your office, on your website, and you've got to orally inform the patient of that. That notice has to contain certain elements. The government has published a form. Again, there's the form for you. The government, it's available at the website that I'll give to you in just a second. If the self-pay person then requests a good faith estimate, which the government has said even includes a request about fees, that's deemed to be a request for a good faith estimate, or when they schedule a primary item or service, then the convenient facility has to provide them with a good faith estimate in a timely manner. In addition, they've got to, within 1 business day of that request, ask any co-providers. Co-providers are other entities that are also involved in the care, that are going to be providing care through, related to the convenient provider's facility. The rules require that convenient facility to contact the co-provider and get information from them to include in the good faith estimate. Now, the rules concerning co-providers have been temporarily postponed. The government has said they're not going to enforce that during calendar year 2022. So we probably don't need to worry about that until January 1st, 2023. So right now, you as convenient providers just need to be concerned primarily about your own fees. That good faith estimate has to be provided within the time required by the regulations, which is generally within 3 days after the time of the request or the scheduled, unless the services are taking place before then. If there is a change in the provider that's less than 1 business day, so in your good faith estimate indicates that it's this provider who's providing the service, but that's changed, then that replacement provider basically has to accept the good faith estimates that's provided by the prior provider. So if you're going to be a replacement provider before you agree, you may want to look at the good faith estimate and make sure you're willing to agree to that. If you're a replacement provider and you have time, you're going to want to provide your own good faith estimate. That good faith estimate has to have required information. Again, the government has published its form available on the website. It has very detailed information that you have to provide, including the items and services that are broken down by codes and charges, any discounts that are applicable, the names of the providers, the locations, and the list of items that require separate billing. It's also got to include a whole list of required disclaimers. And you've got to make sure that that good faith estimate is accurate and complete, because you are likely going to be bound by it. Because under the rules, if the actual charges are substantially in excess of the good faith estimate, That means at least $400 more than the expected charges. The patient may initiate the selected dispute resolution process to challenge the amount that they'd have to pay. In order to initiate that SDR process within 120 days of receiving the bill from that provider, that patient can notify HHS by submitting a form through the HHS website. They also pay a $25 administrative fee. The SDR entity then reviews that to determine whether or not it's appropriate for the SDR. If they determine it is, they will notify the provider. That notice back to the provider kind of acts as a stay of collection action. So once the provider or facility gets notice that the SDR is pending, they may not move the disputed bill to collections or threaten to do so. If the bill is moved to collections, they've got to cease collection efforts, suspend accrual of late fees on unpaid bill amounts, and they cannot take or threaten any retribution against the patient to obtain resolution of the dispute. Within 10 days of that notice to the provider that this is in the SDR, then the provider has to pull together and send to the SDR entity a copy of the good faith estimate that is relevant to the dispute, in addition, a copy of the billed charges that are subject to the dispute, and if available, if it's justifiable, documentation showing that the difference between the billed charge and the good faith estimate reflects the cost of medically necessary items or services, and that there were unforeseen circumstances that could not have reasonably been anticipated by the provider or facility when the good faith estimate was provided. That is the standard for evaluating whether or not you're going to be able to get more than the good faith estimate. If you can't satisfy that standard, you're going to be stuck to what you gave in that good faith estimate. So you want to make sure that you take that good faith estimate seriously and that you provide appropriate information. You're only going to be able to get more if it's medically necessary and there are these unforeseen circumstances. Within 30 days of you submitting that information back to the SDR goes ahead and makes its decision. The decision that the SDR puts out depends on whether or not the billed charges were listed in the good faith estimate or not. If the billed charge is listed in the good faith estimate, then if the billed charge is less than or expected to be the expected charge, the patient pays the billed charge. If the billed charge is greater than the expected charge and the provider failed to provide medical necessity or prove medical necessity and unforeseeability, then the patient pays the expected charge from the estimate, not the billed charge. If the billed charge is greater than the expected charge and the provider proves medical necessity and unforeseeability, then the patient pays the lesser of the billed charge, or if the expected charge or they'll pay the expected charge if the expected charge is greater than the median rate paid by a payer for a same or similar service by the same or similar provider in the geographic areas listed in the independent database, or the median rate if the expected charge is less than the median rate. So you don't automatically get the billed charge, even if you prove medical necessity and unforeseeability. That's if the charge was on the estimate. If the billed charge was not on the estimate, for example, there were additional items that were not appearing on the estimate, then the rules are as follows. If the provider failed to prove medical necessity and unforeseeability, the patient pays zero for that item or services that wasn't on the estimate. If the provider proves medical necessity and unforeseeability, the patient pays the lesser of the billed charge or the median rate paid by the payer for the same or similar service by the same or similar provider in the geographic areas listed in an independent database developed by the government. All right, that's the way that SDR process works. For the self-pay patients, the government again has posted the forms and stuff that you need on its website available at this location. The government's also set up a website for patients to make sure that they're aware of their rights. That is the no surprise billing rule. That will require a lot of effort between now and January 1st. Hopefully you are well on your way. It will change the way you're going to do business in a lot of situations, unless you're willing to just roll over and accept whatever amount that the out-of-network or the players are willing to pay. All right, let's talk quickly about the hospital price transparency rule. This is not a rule, new rule. It's been in effect since January 1st, but there are new penalties that are going to take effect January 1st, 2022. So effective January 1st of 2021, so it's effective now, the hospital price transparency rule required hospitals to publish a list of the hospital's standard charges. That those standard charges had to be published in a machine-readable file for all items and services provided by the hospital, and either in a consumer-friendly list of 300 shoppable services and ancillary services, or in an internet-based price estimator tool, and that has to be available through the hospital's website and updated annually. If the hospitals fail to do that, then the government will monitor that. They could issue a written warning. If you fail to do that, they could require you to comply with the corrective action plan. If that doesn't work, they can impose a monetary penalty of $300 per day, and you also get your name up there on the CMS Wall of Shame. The problem is that apparently those sticks were not strong enough in order to get you actually to comply, or hospitals to comply. Because of that, as part of the 2022 outpatient prospective payment rule, then they increased the penalties. So effective January 1st, 2022, small hospitals still only have to pay, which are defined as less than or equal to 30 beds, still have to pay a maximum of $300 per day. But for large hospitals, which are over 30 beds, then they've got to pay a minimum of $10 per bed per day, up to a maximum of $5,500 per day if you violate that hospital price transparency rule. That means that hospitals now face a range of anywhere from $109,000 per year up to over $2 million per year for large hospitals. So if you haven't been taking that price transparency rule seriously, it's now time for you to do so. The government has a bunch of resources available on its website to help you comply. If you haven't spent time doing that and you haven't got the price transparency rule up and running, you may want to go ahead and do that before January 1st. All right, let's talk briefly about the PRF payments. Remember all that money that came in last year? Well, now it's time to account for all of that money. The government has indicated, hey, we gave you all this money, but we want to make sure that it was used appropriately. And if you fail to use it appropriately, the government can come after you, including potentially False Claims Act penalties and other penalties. The first period, the first reporting period, ended on November 30th. So we are past that. If you didn't file the report then, that means that you violated your terms and conditions, and you must return all the PRF payments from that first period covered by that reporting period, which would be from April 10th, 2020 to June 30th of 2020. Even if you did file that report and you have unused funds that must be returned based on the report, then you've got to return those unused funds by December 30th, 2021. It's really important that you comply with those reporting periods. At least this does not come to a surprise to any of you. Beware of the upcoming reporting deadlines. The next one coming around is period 2. It applies to payments received from the provider from July 1st, 2020 to December 31st, 2020. The deadline to use those funds is December 31st, 2021. So for those funds that came in during that first period, you've got to make sure you use those funds by December 31st, 2021. And the reporting, you've got to do the reporting on that one by March 31st, 2022. If you are not on top of those deadlines, again, you can go to the HRSA website here, and it has a bunch of resources available for you. If you have questions concerning reporting and auditing, the HRSA website has a very long and detailed guidance on FAQs and the like that seems to change. Well, it's better now than it was initially. Initially, it seemed to change every couple of weeks. Now it's a little bit better, but it's a great resource for you in responding to most questions. All right, speaking of fraud and abuse, let's talk about Stark and the anti-kickback statute. Stark, no surprise, has been around forever, but there were recent changes in 2021. In addition, there are additional changes that are going to take effect on January 1st, 2022. The government recently issued their 2022 adjustment of the penalties under the new civil penalties amounts. In addition to having to repay the federal government, you can also get hit up with several penalties of $26,000 per claim or $174,000 per circumvention scheme. That's the penalties under the Stark provisions. There could be additional penalties under the False Claims Act or others. Effective last year, on January 1st or January 19th of 2021, the government issued fairly significant changes to the Stark rules. Among other things, they implemented new safe harbors, including new safe harbors that were intended to cover value-based compensation arrangements. In addition, they issued a very helpful safe harbor that applies to remuneration that you pay to a physician if it's less than $5,000 per calendar year for services rendered, so long as that compensation you're paying is not based on the volume or value of referrals, does not exceed fair market value, and it's commercially reasonable. That's really important because this can now become kind of a catch-all for you. If you had a situation where you had a technical violation and you just forgot to get an agreement in place, but you had paid the physician for providing some kind of medical director services or the like, but you didn't have a written agreement, that would have violated the old rule. But under this new rule, this will allow you to fit within this new exception. So it will minimize your exposure and hopefully avoid some technical Stark violations. In addition, one that kind of flew under the radar screen, which is potentially significant, is it's not a new safe harbor, but it's a new interpretation of an old safe harbor. CMS modified its interpretation of the payments by a physician safe harbor. So this safe harbor applies to payments by a physician now this is payments by a physician, not payments for a physician, but payments by a physician for items or services if the safe harbor applies if you pay that physician fair market, or that physician pays fair market value for the items or services they receive, and the arrangement is not otherwise covered by one of the statutory penalties or statutory safe harbors that apply in 42 CFR 411.357 subsections A through H. So the net effect of this is if you've got a situation where a physician is paying for services, okay, maybe they are leasing space from you. If so long as or maybe a lease isn't a very good example. Maybe they are you're providing some other services to that particular physician. If that physician is paying fair market value, and as long as that arrangement doesn't fit within, for example, the office lease arrangement exception or the personal services exception, which you wouldn't, then you can rely on this safe harbor in addition to other regulatory safe harbors. The benefit of this one is it doesn't have to be in writing, and it doesn't have to include some of the requirements that might appear in, for example, the fair market value regulatory safe harbor. So this is a significant option for you if you have non-compliance and you need to make sure that you want to try to look for a way to bring that back into compliance. The government has significantly broadened this. So make sure you're aware of this new act. They also issued safe harbors for cybersecurity technology and services, isolated transactions, including certain services. They have made additional changes to Stark that are potentially significant, including they clarified and modified the definitions of fair market value and commercial reasonableness, set in advance the volume or value of referrals. They eliminated the period of non-compliance. They now allow you to correct an inadvertent overpayment or underpayment within 90 days of termination of the arrangement. So you've got a situation, for example, where you pay a physician, you made a mistake and you overpaid that physician. As long as you correct that situation during the life of the arrangement or within 90 days after termination of the arrangement, then it's a no harm, no foul situation. If, however, you go beyond that 90 days and you don't, then that would be a Stark law violation. It gives you a 90-day grace period to obtain necessary signatures, and there are some additional requirements if you want to direct referrals to a particular provider. Stark allows you to require contractors or physicians to make referrals to, for example, an employer or a contracted entity, so long as they satisfy certain requirements. They modified the rules for that. So make sure that if you have those directive requirements in your contracts that those are updated to comply with the new requirements. In addition, effective January 1st of 2022, so coming up, they modified the start group practice exceptions. So under the new rules, they modified the compensation portion so that in order to qualify as a group practice, you need to make sure that that you comply with the new requirements for group practice exceptions. Among other things, the changes are as follows. Any share of profits must be based on the profits of all designated health service profits for the group or component of the group consisting of at least 5 physicians, meaning you cannot share some profits from DHS, but not other profits from DHS. If you're going to share profits within the group or within a group of 5, if you're going to share profits from DHS, you have to share the profits from all DHS, not just selected DHS. In addition, if you allocate compensation based on services that are not designated health services, you may only use services that would not be designated health services if it's payable by, if they were payable by Medicare. So Stark had a provision in there that would allow you to fit within the compensation and exceptions so long as you paid providers based on referrals for non-DHS. A lot of people thought that meant as long you could base it on services that would be characterized as DHS if they were payable by Medicare, but since they're not payable by Medicare, then you could go ahead and use that. The government basically said, no, that's not how it works. If you're going to allocate the compensation based on services that are not DHS, it's got to be services that are not DHS, even if they were payable by Medicare. They also added a value-based income option. The bottom line there is you may need to go back and review the group compensation structures to ensure that you're still compliant. They also tweaked effective January 1st of 2022 under the OPPS rule. They modified the indirect compensation arrangement. It's generally only going to apply if you're relying on the indirect compensation exception or definition, and you've got a lease where the amount of the compensation that the referring physician receives, it varies based on the individual unit, and it's a payment for the lease or office space or equipment, or for the use of premises or the equipment. It's a fairly esoteric change, but it might apply in situations where you've got physicians who have a lease interest. They also made some minor changes to the preventative screening tests exception to go ahead and extend to COVID-19 vaccines. They've updated the list of CPT codes that are considered to be designated health services. Those are posted on the CMS website. At least certain services are posted on the CMS website. They announced that going forward, they're not going to publish those in hard copy. They're going to be published solely on the website. That will be updated annually. All right, that's a quick review of the Stark changes. There are also some changes to the anti-kickback statute. They've updated the penalties for violations to $105,000 civil penalty in addition to the criminal penalties. They imposed or established a bunch of new safe harbors, primarily dealing with value-based care arrangements, but they also made some other changes, including, perhaps most importantly, they've modified the safe harbor for the anti-kickback statute for personal services safe harbors. You no longer need to specify the schedule for services that are being provided, and you don't have to specify the aggregate compensation. It doesn't need to be set in advance, so it aligns with the Stark rule now. There are certain other changes to the warranty safe harbor, the electronic health record safe harbor, and the local transportation safe harbor. All right. There really haven't been any changes to ECRA, but I wanted to throw this in just so you remember ECRA. Remember, ECRA is kind of like the anti-kickback statute on steroids. It only applies to referrals for laboratories, recovery homes, or clinical treatment facilities. But if you're involved in referral arrangements with those entities, you've got to make sure you comply with ECRA, or the penalties are pretty draconian, up to $200,000 criminal fine. If you're operating a lab, be really careful about ECRA, especially in the COVID context, right? A lot of you are operating labs and doing a lot of stuff with COVID testing, but a lot of you don't realize that ECRA is out there, and it can pop up and hit you pretty hard. The problem with ECRA, unlike the anti-kickback statute, is ECRA, we don't have any regulatory safe harbors. We have some statutory safe harbors, but they're not nearly as expansive as the regulatory safe harbors. So just don't forget about ECRA when you're considering your referral relationships. The government has also updated its OIG self-disclosure protocol, including an increase in the minimum amounts required to settle under the self-disclosure protocol. An interesting development, in October, the government has also said that it may use the False Claims Act to pursue federal contractors, government contractors and grant recipients who fail to comply with cybersecurity standards. That is a significant issue given the cybersecurity risks that are out there right now. Now, we don't know the scope of this. It's not clear to what extent that might apply to just Medicare or Medicaid participants as opposed to other government contractors, but beware of those issues out there. And this is one that you may want to watch. Just another reason to make sure that you have robust cybersecurity policies and procedures in place. Of course, the most important reason for cybersecurity protection is just the practical effects that it can have on your business, as well as the extremely harmful effects that it can have on your patients. I mean, this is life-threatening. Cybersecurity is a growing problem, continues to be a significant problem for healthcare entities. The government has time and time again published resources to try to help you respond to cybersecurity issues. You're required to do it under the HIPAA privacy and security rules, but the government's provided additional resources, including the health industry cybersecurity practices that they published a couple of years ago that walks through and talks about the top potential risks and gives you practical suggestions for safeguarding. The government has also initiated its Health Sector Cybersecurity Coordination Center that has a bunch of real live ongoing threat analysis and guidance for you. If you're not familiar with that, or if your IT people aren't familiar with that, make sure that they're aware of that because of the cybersecurity risks. While we're talking about electronic data, let's talk about the information blocking rule. There's a lot of misunderstanding concerning the information blocking rule. This rule took effect in April of 2021, so it's in effect now. It applies to actors, including healthcare providers, that's all of you guys presumably, developers or offerers of certified health IT, and health information network exchanges. Well, what does the rule require? It prohibits actors from engaging in information blocking. That is a practice that is likely to interfere with the access, exchange, or use of electronic health information. If the provider, in the case of a provider, the provider knows the practice is unreasonable and likely to interfere, or in the case of a developer or health information network or exchange, they know or should know that the practice is likely to interfere. So the standards are a little bit different. Well, what are the penalties for developers, software developers, or HIEs or HIEs? The government, under the proposed rule, can impose a fine of $1 million. But what about healthcare providers? Well, they can be subject to appropriate disincentives, but we don't have the enforcement rule. This is probably why most of you are not worrying about the health information blocking rule right now, just because we don't have any penalties. But we'll have to see if and when that rule comes out. Well, what are some examples of information blocking? Well, it could be refusing to timely respond to requests to access electronic information, charging excessive fees for electronic information, imposing unreasonable administrative hurdles, imposing unreasonable contract terms, for example, in your HR agreements, your business associate agreements, etc., implementing health IT in non-standard ways that increases the burdens, or other situations. What is not information blocking? Well, remember that information blocking is only acting unreasonably in a manner that is not required by law. So it's not information blocking if whatever actions you're taking are required by law. So if HIPAA or 42 CFR Part 2 or state privacy laws prohibit you from disclosing the information, that's not information blocking. Or if the laws require certain conditions before you may make a disclosure and the patient or other hasn't satisfied those conditions, that's not a violation. However, where the law allows you to make the disclosure, doesn't require it, but allows you to make the disclosure. If you refuse to provide that information, then it may be information blocking. Remember, it's not information blocking if the action is reasonable under the circumstances or if the action fits within a regulatory exception. There's 8 different regulatory exceptions. I'm not going to get into the weeds on those, but these act as safe harbors. So if you fit within one of these regulatory exceptions, it's not information blocking. If you don't fit within these safe harbors, then the question is whether or not you acted reasonably. And so you may be exposed, but it's not necessarily information blocking. For more information on the information blocking rule, again, the government's got a very helpful website. Now, a couple of comments from that website that I wanted to point out because there is a lot of misunderstanding. A lot of people think that the information blocking rule requires you to affirmatively send out or establish patient portals or send out electronic information to your patients, and that's not the case. The rule specifically says there is no requirement under the information blocking rule to proactively make available any EHI to patients or others who have not requested it. It's the request that triggers the information blocking rule. You don't have an affirmative obligation to send it out. We note, however, that a delay in the release or availability of EHI in response to a request or legally permissible access or use may be interference under the IBR. So if you unreasonably delay or deny a request, then that's where it's a potential for information blocking rule. There's a question about, well, are you required to set up patient portals? Again, they emphasize no, you're not required to affirmatively have a patient portal, at least by the information blocking rule. But if you do have a patient portal, meaning that that information is available, then you've got to make sure that the information is available to the patient. When it comes to test results and the like, in that guidance from the ONC, they've said that this could mean a patient would be able to access EHI to test results or other information on the portal in parallel to the availability of the test results to the ordering clinic. Stated another way, there's a question about could, for example, like a lot of our clients might have a situation where they've got a policy that they don't put the patients, they don't allow the patient to look at electronic test results before the physician has an opportunity to review those. In that situation, the government said that that may actually be interference in violation of the information blocking rule. They stated it would likely be considered an interference if a healthcare provider established an organizational policy that, for example, imposed delays on the release of lab results for any period of time in order to allow an ordering clinician to review the results or in order to personally inform the patient of the results before a patient can electronically access such results. It would also likely be considered an interference where a delay in providing access occurs after a patient logs into a patient portal to access EHI that a healthcare provider has, including, for example, lab results, and such EHI is not available for any period of time through the portal. So it doesn't require you to maintain a portal, but if you do have a portal, you better be very careful about keeping information from that portal, especially if there's a request. We're going to have to watch this more closely, watch for more guidance on the ONC's website as this comes out and goes along. Let's talk briefly about HIPAA. In January of 2021, HHS proposed some significant changes to HIPAA, mostly focused around an individual's right to access. For example, as you know, the government has a right of access initiative where they've been going after entities for failing to grant the individual's right of access. The changes to HIPAA kind of take that a step further. Under the new proposed rules, it would allow individuals to take notes or use other personal devices to view and capture images of PHI. You've got to respond to requests to access from the patient within 15 days instead of 30 days as currently exists. You've got to require providers to share information when directed by a patient. So if the patient wants you to share the information to a third party, this would require you to do that. It further limits charges for producing PHI, the amount that you can charge to the patient. In addition to those, the changes would facilitate individualized care coordination, so make it easier to share information through care coordination. It clarifies the ability to disclose, to make disclosures to avert a threat of harm. It lowers the standard that would allow you to use it or disclose it for those. It would remove the requirement that you obtain the patient's acknowledgement of a notice of privacy practices, and it would modify the content of the notice of privacy practices. We don't have the final rule yet. I don't know when that's going to issue, but just realize that that may be coming out. Perhaps the most important thing about HIPAA right now is just realizing how HIPAA may interact with the information blocking rule, because in some sense you may have somewhat conflicting rules. For example, HIPAA may allow you to make disclosures to another entity, for example, for purposes of treatment, payment, or healthcare operations, but it doesn't require you to. Under the information blocking rule, though, however, you may be required to grant that access, so long as it is not inconsistent or prohibited with HIPAA. In addition, HIPAA requires you to respond to a patient's request to access within a certain period of time, currently under 30 days. Under the proposed rule, it would be 15 days. But under the information blocking rule, you may not unreasonably delay access. That means that you may have 30 days under HIPAA, but you may have to give access, likely do have to give access to the patient more quickly than that under the information blocking rule. So just beware of those relationships. Real quickly in closing, while we're talking about patient confidentiality, there were some changes made to 42 CFR Part 2 dealing with the substance use disorder program. These changes actually came out in 2020, but a lot of people weren't aware of it. The CARES Act modified the Part 2 in some fairly significant and helpful ways. They basically make it easier to share information, a Part 2 program to share information with limiting liability. Among the most important things are, it would now allow you to obtain a consent when the patient comes to you as part of a Part 2 program. You can get a consent that would allow you to use or disclose their information for treatment, payment, or healthcare operations like you would under HIPAA. And that consent obtained initially would apply throughout the patient's period of care unless they revoke it. So it's not like you have to get consent each time. Among other things, the CARES Act removed the criminal penalties associated with a Part 2 violation. Now it's just treated like a HIPAA violation. So it basically incorporates the HIPAA penalties applicable to Part 2 violations. There were new Part 2 regulations that were issued in 2020, but we don't have the CARES Act regulations yet actually implementing those items that we just talked about. All right. Thank you very much for your patience as I went through all of that stuff very rapidly. That is a quick overview of kind of what's going on right now, some of the hot issues that are out there. We have additional materials on those items and a lot of webinars concerning the types of items we talked about today that are available. If you want more information about those, you can just go to our website. They're free. If you have any questions, again, feel free to use the chat feature or email me. I apologize for those I haven't responded to in the past few weeks. It's just been a crazy time with all the vaccine mandates and the like. Other than that, I hope you all have great holidays and good luck as we enter into this 2022 time.